Hello family, welcome to A-Level Law. My name is Des and today we are looking at the rule of law and its application to lawmaking, the legal system and substantive law. Let's get right into it. All right, welcome back. So we want to look at the rule of law. Now, you must understand that the rule of law is a symbolic idea. It is a symbolic idea. It is merely that when we say the rule of law, it is a symbol that represents certain ideas and concepts. So it is difficult to give it a precise meaning, a definite meaning of what exactly is the rule of law. However, academic writers have done a great deal of work to be able to, and they've tried to define it in different ways. But however, the main principle is that number one, all people are subject to and accountable to the law. So everyone is under the law. Everyone is supposed to answer to the law. Number two, the law must be fairly applied and enforced. So it must not apply differently to different people, and it must be enforced the same way. If someone kills someone and the punishment is that they are going to be imprisoned for life, it should be uniform for everyone. It should be applied and enforced the same way for everyone. Number three, the process by which the laws of the country are enacted, which means the way they are made, administered, the way they are used, and enforced, the way we make the state makes sure that everyone follows them, the way it punishes people who don't follow them, it must be fair. So the process by which the laws of the country are enacted, administered, and enforced must be fair. Now, the rule of law is a safeguard against dictatorship. It supports democracy. Now, this is because the government and its officials are accountable under the law. So imagine if you are in a country where the president does not report to anyone, there is no law, he is the law. The country will easily fall into a dictatorship, right? Because the president and the government officials, they don't have to answer to the law. They are the law. So the rule of law, it protects, it supports democracy and protects and safeguards the nation against dictatorship. And also the authority is distributed in a manner that ensures that no single organ of the government can exercise power in an unchecked way. And what that means is, if you look at how governments are set up, the government is divided into three parts. We have the judiciary, which is the courts. You have the executive, which is the president, the ministers. In some countries like the United Kingdom, you have the prime minister. Right, this is and the other ministers and their ministries and so forth. They're the executive, and then you also have the legislature, which is the members of parliament who makes the law. So all of these branches of government have some power, but not one branch has all the power. So the legislature, it makes the law. The executive applies the law, it runs the country, but it does not make the law. So every branch of government has some power, but not one branch of government has all the power. And every branch of government reports or is checked by another part of government. So it's sort of monitored by the other part of government. So the executive is monitored by the legislature, right? And then the legislature is the one which creates the laws that the judiciary will apply. And then the executive also is also accountable to the judiciary, because the executive can also be taken to court. So this helps so that there is no one government branch with all the power, and it prevents against abuse of power. Now, let's look at Tony Honoré, an academic lawyer, and how he defines the rule of law. So he points out that the rule of law exists when a government's powers are limited by law and citizens have a core of rights that the government is bound to uphold. And now these rights include, number one, no person shall be sanctioned except in accordance with the law. So it means no one is supposed to be punished except according to the law. So this works both in civil law and in criminal law matters. If you don't understand the difference between civil and criminal law, go back to this playlist. There is a video about the difference between civil and criminal law. Now, number 2, there is equality before the law, and there must be no discrimination on any grounds. So no one must be discriminated against them based on gender, based on race. No one is supposed to be discriminated. It must be fair. Number 3, there must be fairness and clarity of the law. So number 2, we said there must be equality before the law and there must be no discrimination. Number 3, there must be fairness and clarity of the law. We need to know exactly what the law is so that I know if I'm committing an offense or not. So it must be clear what the law is saying. Now let's look at one Professor Dicey, right? He also gives his own understanding and his own definition of what the rule of law is. So the best known explanation of the rule of law was given by Professor A.V. Dicey in the 19th century. So the rule of law, according to him, meant, number 1, an absence of arbitrary power on the part of the state. So when we say arbitrary power, it means unlimited power, right? So it must be absent. We shouldn't give the state unlimited power. So the state's power must be controlled by the law. The law must set limits on what the state can or cannot do. Number 2, equality before the law. So no person is above the law. Everyone is equal and is supposed to be answerable to the law. Number 3, supremacy of ordinary law, or what is called common law. It means common law is supreme. So remember, Professor Dicey, he lived in the 19th century. So in the 19th century, the most dominant law was common law. So if you don't understand what common law is, what the different types of law, sources of laws are, please go back and watch. There's a video on the different sources of law. You can go back to the playlist and watch it. I'll also put it in the description below. But you need to go and look at those videos so you can understand. But just to give you a little understanding, common law is the law that is made by customs, that comes from customs and judicial decisions. So the customs that have been followed by the people and the decisions that the courts have made in the past all form part of what is called common law. And so this was particularly true in the law of England and Wales in the time of Dicey, as many laws had been developed through judicial decisions rather than being created by parliament. Now, let's look at problems with Dicey's views. So a major problem with Dicey's view of the rule of law is that it conflicts another fundamental principle. So there's another important principle in law which is called parliamentary supremacy. So parliamentary supremacy means that an act of parliament can overrule any law and that no other body has the right to override or set aside an act of parliament. So this principle says that we, the people, we vote for the parliamentarians. We vote for the members of parliament. Right? So once we vote for them, and if in countries like the United Kingdom, there's another second house that forms a parliament that is called the House of Lords. This one is not voted for. There's another criteria that they use to select people who get into the House of Lords. But we'll look at it when we do parliamentary lawmaking, so you can check the videos that are coming next on parliamentary lawmaking. But you need to understand that there is also the House of Commons, which is the house, the parliament, part of the parliament where we vote for the people that we want to make the law. So once we vote those people, we give them the power to make the law on our behalf. So according to the law of or the principle of parliamentary supremacy, these people we have given them the power to make the law. So there's no one else with power. There's no other body with power to override the acts that the members of parliament or the parliament would have made. So now, the major problem with Dicey's view of the rule of law is that it conflicts this fundamental principle of parliamentary supremacy. So under the rule of law, right, there should be no arbitrary power of this on the part of the state. That's what Dicey says, right? There should be no arbitrary power or unlimited power on the part of the state. But however, under parliamentary supremacy, if we agree to the principle that the parliament is supreme, the parliament has the right to make any law it wants and it wishes, and this can include granting arbitrary powers to the government ministers. So on one hand, we are saying under the rule of law, the state or the government or the ministers or any branch of the state should not have arbitrary powers. The ministers or the president or the prime minister should not have unlimited power. That's what we are saying under the rule of law. But however, under parliamentary supremacy, we are saying the parliament has the power to make any law it wishes, and even a law that gives arbitrary power or unlimited power to the members of to the prime ministers and the presidents. So you can see how these two principles or concepts are in conflict with each other. So that's the problem with Dicey's view. Another problem is that, according to Dicey's theory, equality before the law refers to formal equality, just equality on paper, because it doesn't take into account, it disregards the differences between people in terms of wealth, power, and connections. So you can have a legitimate case that you're supposed to win because all the facts support you. You are on the side of the truth, but practically, if you don't have the money to hire a good lawyer or to just hire a lawyer, period, you might just lose the case, and there is no equality there practically. In as much as in theory we say there is equality, you can go to the courts, but in practice you don't have the money to hire the lawyer, or you don't have the connections. Some people who have the connections, even if they don't have the money, they are connected, so they will be able to get lawyers to represent them because of their connections. They will be able to do things faster because they are connected to the system and all of these things, right? Some people have power, right? They can be able to even control, when we say that the judiciary has been captured, we mean that there are people who are now controlling the judiciary. They are no longer independent. The judiciary is supposed to be independent. The courts, that's what we are calling the judiciary. They're supposed to be independent so that they can be able to decide on matters independently and fairly without being influenced by anyone else, including government officials. So when it comes to Professor Dicey's views, it's just formal equality. It's not really practical equality. Now, there has been changes in the 21st century which supports the principles of the rule of law. So a major example is the Constitutional Reform Act. So this is an act that was passed by the Parliament, which is a law that was made and passed by the Parliament, which recognized the rule of law and the importance of the independence of the judiciary. So Section 1 states that this act does not adversely affect. So it says this act does not negatively affect. So in other words, it's saying we are still protecting these things. Number one, the constitutional principle of the rule of law is not negatively affected. So we are saying we're protecting it. The Lord Chancellor's existing constitutional role in relation to that principle. So the Lord Chancellor is sort of like the Minister of Justice. So his existing constitutional role in relation to that principle, we are saying that it has not been negatively affected. So we are saying it is still protected. Section 3, subsection 1 states that the Lord Chancellor, other ministers of the Crown, and all with the responsibility for matters relating to the judiciary or otherwise to the administration of justice, they must uphold the continued independence of the judiciary. So we are saying these ministers, they must uphold, they must make sure that the judiciary is kept independent. This is important because under the rule of law, the law must be applied fairly. So for that to happen, the judiciary must be independent. They must not be influenced by anyone. They must not be influenced by politicians. They must not be bribed and all of these things. So that is supporting the rule of law. So these safeguards shows the importance that is attached to the rule of law. The rule of law and lawmaking. Let's look at that. Now, the rule of law is important when it comes to lawmaking. The process by which laws are made must be open and fair. This supports the rule of law, right? We're saying the law must be fair. So the process by which the laws are made must be open, it must be transparent, everyone must know what's going on, and it must be fair. But how do we do that? Number one, acts of parliament have to be passed by both houses of parliament. So we said we have what is called the House of Commons, which is the house that is made up of people who are voted for by the masses. And then we also have what is called the House of Lords, which is also made up of people who are selected based on certain criteria, which we will look into when we do parliamentary lawmaking. But we have these two houses, right? So acts of parliament have to be passed by both houses. So the House of Commons should agree, the House of Lords should agree, and after that, then the law can be made, can come into force. So in practice, the government of the day usually has the majority in the House of Commons, which means that the ruling party will have the majority of MPs in the House of Commons. So most laws that the government or the ruling party proposes will be passed by the House of Commons. Although there can be debates in the law, and which can also lead up to certain changes being made in the law, but they usually the laws will usually pass the House of Commons, because usually it will be dominated by the ruling party, so they will vote for it usually for the law that they want. However, the House of Lords will exercise a check on the lawmaking process. So after you have decided, the House of Commons, the party that has most people usually makes their laws because they are the majority. Usually that's what happens, right? So after they've decided this is the law that we want to make, it doesn't just become law, right, because they want it. It has to be also agreed upon by what is called the next house, which is called the House of Lords. So this provides a check, right? So it makes sure that the House of Commons does not just make whatever law it wants and it just passed. They also are there to make sure that the laws that are being made are correct, are good laws. So they have to also agree. If they don't agree, then it doesn't come into law. Government ministers can also make laws by statutory instruments. So they are called statutory instruments. These regulations do not always have to be considered by the parliament before they come into force. Right? So we are saying there are some laws, right, or regulations that government ministers can make, not the parliament, but the ministers will be the ones making these laws, right? So the ministers, in certain situations, they're given power to make those laws. So, for example, it is important to understand this because, for example, there are some laws that we need to be able to make fast. So, for example, if you are the minister of the local authority minister, for example, and you want to make laws on, for example, how people should park their cars in certain areas. In many situations, you are given the power to make those laws. Or, for example, you're the Minister of Transport and you want to make some laws concerning aviation, of how aeroplanes are supposed to fly through airspace and stuff like that. Usually, the parliament will give you the power to make those laws. So, the parliament... So there are several checks, right, to make sure that the minister doesn't just make any laws that they want, right? So number one, the parliament must have previously passed an act that is granting power to a minister to make statutory instruments. So the laws that are made by the minister are called statutory instruments. And the minister, before he can be able to make those laws, he must have been granted that power by an act that was made by the parliament. Number two, the parliament also has the power to scrutinize and check the instrument. So the parliament can be able to say, when it comes to that law that you make, let's talk about it. How did you decide this? They are there to be able to scrutinize it and see if it is in accordance with the law and if it's good. Right? But it doesn't. But it doesn't have to be passed by the parliament like any other type of law that is passed by the parliament in acts. These statutory instruments, the minister can make them and then publish them and say it's law and sign them, and that's it. Number three, the statutory instruments can be challenged in the courts through a judicial review to make sure that the minister has not gone beyond the powers granted by the parliament. So if there is someone who's affected by the statutory instruments that has been made by the minister, he can approach the court and say, the minister has gone beyond the powers that he has been granted by the parliament. He has made laws that are outside his power to make, outside the jurisdiction or the power that he has been given by the parliament to make. Now let's look at the rule of law and the legal system. Now, the rule of law also covers the way in which the legal system works. One of the most important points is that every defendant in a criminal case must have a fair trial, right? So that's how the rule of law affects the legal system. Number two, a trial by a jury is seen as an important factor in maintaining fairness and protecting the citizens' rights. Number three, no person can be imprisoned without a trial. So going back to number two, trial by jury is where there are many people, a jury of people, a jury, right, which then decides whether a person is guilty or not. So it's seen as an important factor in maintaining fairness and promoting the citizens' rights. And then we said no person can be imprisoned without a trial. And then number four, the system should be free from discrimination, free from corruption, and not properly influenced by public officials. Politicians, hear me and hear me well. The system should not be influenced. So if you're looking, because I know law students, you guys, some of you want to become politicians, and we are here to tell you that the system, make sure when you become politicians, you do not improperly influence the public, the system, the legal system for your own advantage. Be a good politician. Be a nice one, right? Be a nice one. So the civil justice system should be accessible and affordable. Everyone should be able to access it. It should not be for the rich only. It should be affordable, right? There should not be classes of people who are not allowed to go to the courts, and it should be affordable. Everyone should be able to afford to get justice. Now, before we get to the next part, I want us to look at the definition of what is called substantive law. So substantive law is the law that says what is allowed and what is not allowed. Now, for you to better understand it, let me give you the opposite of substantive law. It is called procedural law. So procedural law is a law that says how to deal with it when someone breaks the rules. So substantive law is saying what is allowed, what is not allowed. Right? It is giving you the do's and the don'ts. Substantive procedural law, it is showing you how to deal with it when someone breaks the law. How do you go about it? You don't just beat them and put them in prison. There are processes that you have to follow. So to illustrate the difference, for substantive law example, a person is guilty of theft if they take someone else's property without permission. So substantive law is telling you this is what theft is. Procedural law then says to prove that someone is guilty of theft so that you can be able to punish them, certain evidence must be presented in court and the trial must follow specific procedures. So it has to go through the different stages of the trial and all of these things. So the procedural law is showing you what you must do now to make sure that the law is enforced and that people who offend are punished. Now, so substantive law, the definition is substantive law defines the rights and the duties of individuals. So it defines your rights and the duties, the things that you must do as well, of individuals, organizations, and establishing the rules and the standards that govern behavior. So you just don't behave the way you want, right? There are rules, there are standards that govern the way we must behave. Remember, we talked about Tony Honoré, right? That they must, and he said substantive law means there must be fairness and clarity of the law. There must be fairness and clarity. The law must be clear. What is it saying? So substantive criminal law sets out the definitions and the penalties of criminal offense. So it tells us what is criminal offense, right? When we're looking at substantive criminal law. Now there is substantive civil law, but when we're looking right now, what we're looking at is substantive criminal law. Again, if you don't know the difference between civil and criminal law, go and watch the video on the difference between civil and criminal law. Now, so criminal laws serve several purposes. Number one, to protect the citizens. For example, laws concerning murder, manslaughter, and non-fatal offenses against the person. So those laws are meant to protect people. It is also meant to protect people's property. For example, laws concerning theft, burglary, criminal damage, and robbery, things like that. It is also meant to prevent disruptive behavior and to protect public order. So we don't want disruptive behavior, and we want to protect public order. There are also what are called regulatory offenses, right? These are aimed at issues such as driving offenses. So for all offenses, the law has to be clear. We have to know what the law is saying, what is the position of the law, and the prosecution has to prove that the defendant has committed the offense before they can be considered guilty. So all offenses have a stated maximum penalty, right? So all offenses, there's a maximum penalty that if you rape someone, the maximum you can go to prison is 20 years. The judge cannot then say, you're going for 100 years because I feel like you should go for 100 years. No, there has to be a maximum penalty, and the courts cannot impose a higher penalty. Now let's look at substantive law, substantive civil law of tort, right? So substantive civil law of tort, it sets out the rights and responsibilities people owe to each other in every right. So when we're looking at civil law, or when we're looking at what is a tort, right? A tort is a civil wrong or injury. So a tort is different from crime. It is a civil wrong or injury. It's not something that is a crime that you have to be going to prison for. A tort is when you, for example, you say things that damages someone's reputation. That's defamation of character. Now you have to pay damages. You have to pay for what you did. So you have to pay them some money. You have to probably issue a public apology, right? So those are torts. Or for example, you damage someone's property, right? For example, in an accident, you get into an accident with someone and you were not, it was a mistake, you hit someone's car. That's a tort, right? It's a civil injury, it's a civil wrong, but you have to pay, you have to compensate that person. So unlike criminal law, where the prosecution is nearly always brought by the state, so the state is the opposing party in a criminal law, right? In civil law of tort, it is the person affected by the tort who makes the claim. So a considerable problem is that public funding for making a claim in tort through the courts is no longer available. So this means that although everyone has, in theory, the right to claim, financial issues can come into practice, making it difficult for a person who is poor to make a claim because they cannot pay the monies that you're supposed to pay when you are doing things in the court, and even to hire a lawyer, you're not able to do that. But however, there are what are called conditional fee agreements that can be used to fund such cases. So, for example, you can agree with the lawyer that I don't have money to pay you, but you can represent me when I win the case. You take 25% of the money that I'm going to win. But the problem with that is you have to prove at a very early stage to that there's a good chance of success. Otherwise, no one will want to represent you if they don't believe that you're going to win the case, even though you believe that you're going to win the case. Then we look at substantive civil law of contract. So a contract is an agreement between two people, right? So substantive law of contract, right? Civil law of contract, it lays down the rules of when a contract is formed, what should happen before we say a contract has been formed. It tells us the rules of what may make a contract void or voidable, right? So sometimes a contract is considered void because maybe you've made a contract with a 5-year-old. A 5-year-old cannot make a contract according to law. So that contract is void from the beginning, right? Then there are situations where the contract can be considered voidable, right? So for example, you make a contract, but you don't, there is part of the law that you did not take into account, right? That if maybe the other party can then say, oh no, this part of the law is not taken into account, which means the contract can potentially be made voidable. We can say, no, this contract has no effect because we did not follow that part of the law. Or there are situations where the law allows you that even though you did not follow some part of the law in making that contract, it can still also allow you to say, if you want to continue with this contract, you can continue. So those are the kind of contracts that are voidable. But there are other contracts that are just void. If you make a contract with a 5-year-old, it's void. Even if you can prove it was made or whatever, it is void. It is not a contract. You have not made any contract. It also lays down rules on what can amount to breach of contract. What does a person, when we say breach of contract, it means you have broken our agreement. What does a person have to do for us to say they have broken our agreement? That's also part of substantive civil law of contract. So contract recognizes that in most cases, people are free to make whatever agreements they wish. However, it also recognizes that consumers have very little choice when making contracts with the businesses. So if you're buying something from the shop, usually you have very little choice, right? You're just taking the deal that they're giving you. This is for, we're selling this to you for $20. So if you don't want, you leave it. So because the contract law recognizes that consumers may have very little choice when making contracts with businesses, and that there is not really equality between the parties, right? In order to then bring about that equality, that greater inequalities, some rights are given to customers. So for example, the law can give rights to customers to say, if you buy a car, regardless of what the person told you, if you buy a new car, a brand new car, you must be given, if it breaks down within 1 week, or within 6 months, you should be able to take it back and be given a new one. That's where the law comes in to protect the consumer. Now let's look at substantive civil law of human rights. So human rights are the right to human dignity, all the human rights, the right to not be fairly discriminated against, the right to life, things like that, right? So human rights law supports the rule of law in many ways. For example, all rights must be fairly applied without discrimination. So all rights, its rights there, must be fairly applied without discrimination. Congratulations. Well done, well done. You've come to the end of the video. If this is adding any value to you, I want you to do me a favor. Smash that subscribe button, hit that share button, tell your friends, like, and if you also want to join our online school, we have an amazing team of lawyers that are ready to work with you online full-time, and you'll be able to get your A stars and get amazing results. So if you want to work with us online, we offer A-level law and many other subjects. So just check the details in the description of our channel or the details in the description of this video, and we've got you. Until next time, bye.